The cases that keep coming back: illegal charter, sham leases, and operational control. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now, let's begin with a recent regulatory case pattern that most clearly tells us where the pressure is building in large turbine aviation, and that is illegal charter dressed up as something else. In the abstract, that sounds technical. In practice, it's one of the most commercially important and legally dangerous issues in business aviation. The reason is simple. A large turbine aircraft is expensive to own, expensive to crew, and expensive to leave idle. The economic pressure tempts owners, managers, and intermediaries to look for creative trip structures that promise charter-like revenue without charter-like certification. The FAA regulations are not designed to tolerate that kind of creativity. Part 119 applies to persons operating or intending to operate as air carriers or commercial operators, and Section 119.5 prohibits operating as a direct air carrier or commercial operator without the appropriate certification and operation specifications. FAA guidance in AC 91-37B make the same point in plain language. Operational control is a matter of legal responsibility, and a lease does not become lawful just because the paperwork says dry lease. That is why the 2025 federal civil penalty action against Walter Buss and Prairie Flower Air Asset Company deserves close attention. According to the public complaint and the related Department of Justice announcement, the government alleges that Prairie Flower knowingly operated as a direct air carrier without FAA certification, used dry leases as a device to evade the certification rules, conducted at least 237 flights for clients under those arrangements, and committed at least 16 regulatory violations on each alleged unlawful flight. The allegations also include claims that some pilots had not completed required competency or instrument proficiency checks, and that Buss himself illegally flew the aircraft on some occasions. Why is this case important? Why should it be considered? Because it captures how these situations arise in the real world. They usually do not begin with someone announcing, let's violate Part 119. They begin with a familiar business aviation sequence. An owner wants to offset carrying cost. A broker or intermediary brings a trip opportunity. A management structure already exists. The aircraft is available, and someone convinces himself that a dry lease, reimbursement formula, or paper allocation of responsibility will solve the problem. That is how regulatory risk enters the aircraft without ever appearing in the marketing deck. The FAA's Safe Air Charter materials make clear why the agency cares so much. True charter under Part 135 requires a higher level of training, certification, maintenance procedures, and safety oversight than ordinary private carriage. The rogue operator warning signs published by the FAA are telling. They ask whether the passenger was coached on what to say, whether the operator was truly authorized, and whether the passenger actually had operational control. Coaching a passenger to say, I decide where and when to fly, even though it was the pilot's decision. Those are really not academic questions. They are exactly the questions that show up later in investigations, enforcement actions, and potentially lawsuits. A second recent appellate example makes the same point from the pilot's side. In Bonnet versus Whitaker, the First Circuit upheld a 270-day suspension of the ATP certificates of two pilots who flew a Cessna Model 650, registration number 51 Juliet Victor. The aircraft required two members, had a seating configuration of up to 20 seats and was used for flights that the FAA and NTSB treated as common carriage for compensation. The pilots argued, among other things, that they received no extra compensation for those specific flights. The court still upheld the agency, emphasizing the commercial charter of operations, the way the flights were booked and invoiced, and the applicability of Part 135 requirements. This case is memorable because it destroys a common misperception. Many pilots assume the compensation analysis turns only on whether the pilots got paid more for a specific trip. Bonet shows that it is far too narrow. The legal question is broader. What was the nature of the operation? Who was undertaking to transport passengers? How was the trip sold or arranged? And what regulatory regime was actually applied? This is also why large turbine aircraft deserve special attention in this area. Once you are dealing with cabin class jets, two-pilot crews, cross-border itineraries, business guests, and pricing structures that look like transportation sold on demand, the facts start to resemble commercial carriage very quickly. The paper may still say private, the operational reality may say otherwise. So, the first deep lesson from the recent cases is this: illegal charter litigation is usually not about a single bad clause. It's about factual gravity and inconsistency. The closer the arrangement looks, feels, and functions like air transportation offered for compensation, the more likely the FAA, DOT, and ultimately a court will treat it that way. Practically, that means owners and operators of large turbine aircraft should ask 5 questions before every non-owner trip. And these are important. Who selected the passengers? Who set the itinerary? Who bore the operational risk? Who had the legal authority to start, delay, or cancel the flight? And who is really selling the transportation? If the honest answer points back to the owner, manager, or broker rather than the purported lessee, the structure may already be in trouble. In short, recent illegal charter cases teach that most dangerous large turbine deals are often ones that are marketed as efficient, flexible, and commercially sensible. While those descriptions may be true, but if the regulatory structure is false, the efficiency is temporary and the exposure becomes very real. Here's something to remember and take away. In large turbine aviation, the quickest way to create a court case is to call a charter something else and hope that the facts stay quiet. The paperwork case. That is not just paperwork, registration, airworthiness, and pilot's responsibility. Now let's turn to the second most litigated theme, and it is one that sophisticated operators routinely underestimate. Paperwork defects on a large turbine aircraft can become airworthiness defects, certificate defects, and enforcement defects all at once. That sounds harsh until you remember how the FAA regulatory system works. A turbine aircraft does not become lawful because everyone involved subjectively believes the operation is harmless. It becomes lawful because the aircraft, the documents, and the operation line up with the registrations. When they do not, a court will often defer heavily to the FAA and NTSB. A vivid example of this is Hardwick versus FAA, decided by the Fifth Circuit in March of 2026. The aircraft was a Cessna Citation 550. Its owner had changed the tail number from 550 Mike Echo to 550 Mike Kilo, obtained new registration documents, but did not obtain a new airworthiness certificate reflecting the new registration because additional inspection work was still needed. The physical tail number was then altered back to the old with tape, and the aircraft carrier carried a mix of old and new documents. That fact pattern almost sounds absurd, which is one reason it is so useful for teaching. Many aviation professionals hear a story like that and think that is just an administrative mismatch. The Fifth Circuit didn't treat it this way. The FAA inspectors warned the pilot that further operation would violate the regulations. He flew the returning leg anyway. The FAA suspended his license for 150 days. The NTSB affirmed, and the Fifth Circuit denied review. The reasoning and the court's reasoning here matters. It upheld violations involving the display of the proper registration marks, civil aircraft airworthiness, and the requirement to carry a valid airworthiness certificate with correct registration number. It also rejected the idea that the pilot could escape responsibility by relying on the owner's explanation. So, in other words, a professional pilot flying a turbine aircraft was expected to independently confront the regulatory problem, not merely inherit someone else's paperwork story. Why is this so important for large turbine aircraft? Because modern turbine operation runs on authorizations, status documents, and configuration specific permissions. Tail number changes. Reduced vertical separation minimum, or RVSM authority, letter of authorization, LOAs, minimum equipment list, MEL, status, international approvals, maintenance sign-offs, and airworthiness documentation are not peripheral to the flight. They are part of a legal condition of the flight. That is why one way to describe Hardwick is a warning against the phrase, it's only paperwork. It's a warning against that. It's always more than just the paperwork. In large turbine aviation, paperwork is often the visible edge of a deeper compliance problem. If the documents do not line up, the first question should not be whether the mismatch looks harmless. The first question should be what legal authority the aircraft actually has at the moment to fly in the condition presented. A related point emerges when you put Hardwick next to the earlier RVSM and authorization cases in this area. Courts have repeatedly been unreceptive to the idea that a pilot can solve a documentation problem by trusting the operator, the owner, or an outdated set of paperwork. That is especially true where the pilot was on notice that something was wrong. Once notice existed, continuing flight can look less like a mistake and more like disregard. That's what you had here, was disregard. This is one of the great misunderstandings in business aviation. Sometimes owners sometimes assume the pilot owns the problem. Pilots sometimes assume the owner or manager owns the problem. Managers sometimes assume maintenance or registry counsel owns the problem. The cases teach us the opposite lesson. The FAA can divide the responsibility among several actors. The person in the left seat may still face certificate action, meaning the pilot in command. And there's a second practical reason these cases matter. They're not limited to bizarre fact pattern. Any large turbine aircraft can drift into the same kind of trouble through rushed closings, delayed conformity work, incomplete registration changes, missing special flight permit analysis, sloppy records transfer, or misunderstanding about whether a modification, inspection, or certificate has actually been completed. High-end operations often create a false sense of procedural reliability precisely because so many people are involved. So why should operators what should operators do with that lesson? First, treat every registration or certificate change as a no-fly event until full documentation chain and a full documentary chain can be established. Second, require one person to reconcile the physical markings, registration record, airworthiness certificate, and any operating authorization before release. Third, When the FAA or an inspector identifies a defect, do not convert a fixed issue into a sanctions case by launching anyway. And fourth, train crew that administer or administer irregularities. And remember that administrative irregularities can ground aircraft. The memorable point is this: on large turbine aircraft, regulatory paperwork is not office work, it is dispatch work. In short, the recent documentation cases teach us that courts do not separate paperwork from safety as clearly as operators often do. When the papers govern identity, airworthiness, and authority are wrong, the aircraft can become largely unairworthy and legally unairworthy, even if the engines are running smoothly. Here's a takeaway to remember. A large turbine aircraft does not need a mechanical failure to create a regulatory case. Sometimes mismatched documents are enough. And usually it starts with mismatched documents. The border is now a regulatory trap. Sanctions, export controls, and seizure risk for large turbine aircraft. Finally, let's discuss the third recent litigation trend. And it may be the most underappreciated in all of the large turbine market. The business jet is no longer regulated only by the FAA. Once the aircraft crosses borders, sanctions law, export control, customs rules, and asset forfeiture law can move from background noise to center stage. That point is not theoretical. In March of 2025, the United States filed a verified civil forfeiture complaint in the Southern District of Florida against a Dassault Falcon 900EX, tail number Tango 7, Echo Sierra, Papa Romeo Tango. The complaint alleged that the aircraft was purchased through a nominee structure, smuggled from the United States under false pretenses, and operated for the benefit of Nicolas Maduro and representatives of the Maduro regime in violation of U.S. sanctions and export control laws. The complaint specifically invokes IIEPA, the Export Control Reform Act, the Export Administration Regulations, smuggling statutes, and money laundering theories. The government's theory is worth close study because it reflects how these cases actually develop. According to the complaint, the structure allegedly used a foreign company as a straw purchaser, concealed the true end user, routed funds through multiple jurisdictions, and treated the aircraft as a tool of mobility for a sanctioned regime after export. That is not just a bad closing. It is a map of modern cross-border aircraft risk. This situation case became even more significant because it did not stand alone. The Justice Department separately announced the February 2025 seizure of a Dassault Falcon 2000EX allegedly used by PDVSA, the sanctioned Venezuelan state-owned oil company. According to the government, that aircraft had been illegally serviced and maintained using U.S. origin parts and support in violation of sanctions and export control restrictions. That is a crucial point for large turbine operators. The regulatory exposure may arise not only from the original sale, but also from maintenance, parts support, and continued operation. So why is this so important for business jets and other large turbine aircraft? Because these aircraft are uniquely suited to become evidence. They have identifiable serial numbers, stable registration histories, maintenance records, flight histories, service footprints, and international movement patterns. They are expensive enough to justify aggressive government investigation, and mobile enough to cross multiple legal systems in a short period of time. These cases also show that the compliance failure is often human before it's technical. Someone accepts a beneficial owner explanation without drilling down. Someone treats a newly formed foreign holding company as a real operating principle without asking who actually controls it. Someone files or approves export information without matching it to the real destination, end user, or end use. Someone authorizes maintenance support because the aircraft is physically present and the work looks routine. In a sanctions case, the sequence can become the record of knowledge, concealment, or willful blindness. The regulatory framework explains why. The Venezuelan sanctions regulations block dealings for the benefit of the Maduro regime and related blocked parties. The Export Administration regulations impose licensing restrictions tied to end user, including military and military intelligence end users. And the federal smuggling statute reaches exports or attempted exports made contrary to U.S. law. When those authorities are combined in a forfeiture complaint, the aircraft itself becomes the defendant, and the transaction history becomes the proof. There is a broader lesson here for large turbine transactions. Lawyers and deal teams often focus heavily on title, tax, registration, and financing. All of that still matters, but the recent forfeiture filings show that beneficial owner diligence, sanction screening, export classification analysis, and service support controls now belong in the core transaction checklist, not in a late-stage compliance appendix. This is especially true where the aircraft will be based abroad, operated by a foreign principal, and serviced outside the United States, or used for politically exposed persons, state-connected enterprises, or opaque holding structures. A beautifully documented purchase agreement cannot protect an aircraft from seizure if the underlying end-use story is false. So, what's the practical strategy here? Start with the real buyer and real end user, not the nominal buyer. Confirm who will control and benefit from the aircraft after closing. Screen owners, users, brokers, operators, and maintenance vendors for sanctions exposure. Confirm whether export filings, license requirements, and end user restrictions are implicated before delivery, and again before major cross-border movement or support. And remember that U.S. origin parts and technical support can create fresh legal risk long after the original acquisition closes. The memorable closing point is this: a large turbine aircraft crosses borders quickly, but legal risk crosses with it. In short, the recent cross-border aircraft cases show that a business jet can move from prized asset to seized asset when the transaction file hides the true user, the true destination, or the true purpose. For owners, operators, and advisors, that means regulatory diligence can no longer stop at the FAA registry. Remember this: in modern large turbine aviation, the border is not the end of regulation. It is where the most expensive regulation begins. Thank you again for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Please direct questions, and questions are welcome to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues and answer your questions with precision.